Question number 11, Iain Lees-Galloway.
Thank you, Mr Speaker. My question is to the Minister for Workplace Relations and Safety.
I'm sorry to interrupt the member. If the member was unhappy, she should have risen to her feet at that occasion, not by interjection subsequently after calling her colleague. Number 11.
Point of order then, Mr Speaker, if I need to get to my feet.
Honourable Annette.
Mr Speaker, if you go back and look at the answers to the Minister of Health today, at the end of nearly every answer, he has referred gratuitously to the time that I was Minister of Health. I wasn't asking
Member
about when I
will
was
return
Minister of
her
Health.
feet. Question number 11, Iain Lees-Galloway.
Thank you, Mr Speaker. My question is to the Minister for Workplace Relations and Safety and asks, does he stand by all his statements regarding workers employed by CNR Dalian Locomotive working in New Zealand? Speaker.
Honourable Michael Woodhouse.
Yes.
Supplementary question, Iain Lees-Galloway.
Will he clarify the law so that all people working in New Zealand have the same rights? For example, the right to be paid at least the minimum wage and the right to be safe at work. If not, why not?
Honourable Michael Woodhouse.
No, because there is no because all people working that are subject to minimum employment standards in New Zealand are already well covered.
Supplementary question. Supplementary question, Iain Lees-Galloway.
Point of order, Mr Speaker.
Point of order, Iain Lees-Galloway.
Mr Speaker, my question was, will he ensure that all people working...
Order. The member wants to go back now and study his question. The question was, will he clarify and change the law, or words to that effect? And the Minister straight away said no. Further supplementary, Iain Lees-Galloway.
Why did he compare the railway workers who have been working in New Zealand for at least 6 months with pilots and cabin crew who are here for only a matter of hours?
Honourable Michael Woodhouse.
Mr Speaker, I made the analogy of a pilot because the circumstances are similar. The workers at the hut workshops are employed offshore by a foreign company. They are under employment agreements governed by Chinese law and are only in New Zealand to carry out work under a warranty agreement with Kiwi Rail. MB concluded that it was unlikely New Zealand employment law applied.
Supplementary question.
Order. Supplementary question, Iain Lees-Galloway.
Why did he state that he is, quote, very happy with the circumstances under which the employees of CNR Dalian Locomotive were asked to do the work in New Zealand, given that the Labour Inspector was unable to determine if the workers were receiving minimum wage, annual leave or bereavement leave, and could only guess as to whether they received sick leave and paid public holidays?
Mr Speaker.
Honourable Michael Woodhouse.
Mr Speaker, the circumstances as described by the member in his question are absolutely incorrect. MB were able to establish that they did not work on public holidays, they did not work when they were sick and were receiving paid sick leave, paid holidays. They did not find any evidence to support allegations that they were living in cramped conditions or allegations suggesting they had limited access to food. And when they were asked to provide wage records, the workers themselves told MB to mind their own business. It's a private matter between them and their employers, and they didn't make the complaint.
Supplementary question.
Supplementary question, Sue Moroney.
Thank you, Mr Speaker. Has he informed Immigration Minister Michael Woodhouse of his view that these workers are not covered by New Zealand employment law? And will he therefore recommend to the Immigration Minister, Michael Woodhouse, that they should have their work visa revoked to protect New Zealand employment standards?
Honourable Michael Woodhouse.
Mr Speaker, I have been diligent in consulting my colleague, the Minister of Immigration, and he is very satisfied that the Chinese workers in this instance were on short-term visas and generally no more than 3 months per year, and as such their entry was tied to the terms of the original contract and warranty. I should note, Mr Speaker, that those terms are actually covered by a free trade agreement that the previous Labour government put in place.
Supplementary question.
Order. Supplementary question, Iain Lees-Galloway.
Why is it appropriate to ensure that workers on foreign fishing vessels working in the New Zealand zone do get entitlements of minimum wage and other minimum employment standards, but workers in other situations do not?
Order. Honourable Michael Woodhouse.
Mr. Speaker, workers employed by foreign charter vessels are in a very different situation.
No, they're not.
Foreign charter vessel workers are fishing in New Zealand.
Everybody working in New Zealand should get minimum standards.
Order! That level of interjection from a member asking a question is totally unsatisfactory. Would the Minister now complete his answer?
Those workers are fishing in New Zealand-controlled waters for permit holders that are based in New Zealand. The government has introduced reforms that should ensure compliance with both New Zealand employment and maritime laws. The Chinese workers, on the other hand, are in New Zealand temporarily on behalf of their Chinese employers to undertake warranty work.
Question number 12. Question number 12. Marama Fox.